Welcome to Sakshi TV special immigration show with attorney Mr. Parvathaneni from Managing Attorney at law firm of Sim Parvathaneni and Brown. Please note that Sakshi TV now has 3 immigration shows every week on Tuesday at 3 p.m. EST with attorney Ms. Sheila Murthy, Wednesdays at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with Banu Ilindra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 866-725-7441. Before we begin the show, please note that the information provided on the show is not a legal advice and for general information purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need specific legal advice, please contact the attorney directly. Mr. Chan needs no introduction, but if you need consultation, please log on to spplawfirm.com. And when you connect them, don't forget to mention Sakshi TV. From the beginning, spblawfirm.com has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The www.spblawfirm.com site provides you with the latest and cutting-edge information on US immigration laws and policies explained in terms you don't have to be a lawyer to understand. Hello, Mr. Chan. Before we get on to the show, can you please tell us about the recent immigration updates this week?
Sure, Shivani. So we have a couple of good positive updates, and this is probably because of the guidance that came out last month that is impacting the L2 visa holders and the H4 visa holders. So the guidance that came out last week streamlined the way people are authorized to work if they are on L2 status or H4 status. The biggest the positive news is for the L2 spouses. So the L2 spouses can now work incident to status. What that means is they don't have to do any employment-based employment authorization filing, and they can directly start working once they have their I-94 that shows that they are the spouse of an L1 visa holder. The H2, the H4 employees, the H4 spouses, they still have to apply for the I-765 employment authorization. But the good news is that a lot of them, at least under certain circumstances, will be able to utilize the automatic extension that will be granted if they timely file the H4 EAD extension filings. So this is good news. USCIS published a huge guidance on their website, and the guidance is what will drive the employment authorization for the L2 spouses and for the H4 spouses going forwards.
Yes.
And apart from that, on the green card side, the December bulletin was not very promising. The January bulletin is probably going to come out in the next couple of days. And we don't really expect any surprises in the January bulletin. But that being said, in the current bulletin, for the current month of December, you can still use the second chart. So if anybody is looking to file for their green cards, their I-485s, you should be able to utilize the second chart and do your 485 filing. And I think starting this month, what's going to happen is a lot of people will start upgrading from EB3 to EB2, because now EB2 for India has moved ahead of EB3 after many months. So starting with this month's bulletin, the thing is that EB2 has moved ahead, and that's probably going to continue for the next couple of months. We do not think that EB3 will move ahead of EB2 in the next few months. So anybody that could upgrade probably should upgrade. Probably people should start looking at interfiling if they have both EB2 and EB3 approvals. And depending on the circumstances, probably a new 485 filing might be beneficial for some people. So for anybody whose date is current under EB2 in this December month's bulletin, definitely talk to your attorneys who have done your 485 filing, especially if you have done a downgrade last year when EB3 was moving faster. Check with your attorneys and see if a new 485 filing makes sense or interfiling makes sense, because a lot of people this month are looking at either interfiling or new 485 filing because of the EB2 dates going ahead of the EB3 dates. That's all in terms of the updates for this week.
Yes. Yes, Mr. Chan, can you explain us what are the nuts and bolts of H1B visa?
Sure. So H1B visa, this is the most popular way most of the Indians work in the United States. So many of people start their career in United States, their employment career, typically by getting on H1B visa and working on H1B visa. And just a brief history about the H1B visa. So the H1B visa has roots in an act that was passed in 1952. So in 1952, the Immigration and Nationality Act that was passed created a program called H1. It was not H1B, it was H1. So H1 visa was created in 1952. And then in 1990, there was a major update to the Immigration Act. So this is called as the Immigration Act of 1990. So it was during this act that the H1B program was created. So the H1B program, as we know it now, was originally created in 1990. And since then, many modifications were done. But again, the essence of the program was created in 1990. And currently, every year, 85,000 new H1B visas are available every year under the current regulations. So this H1B visa, it allows somebody who's not a citizen or a green card holder of USA, some foreigner, to come temporarily to US and work in the United States in a specialty occupation position. So it's not just any job, but it has to be a specialty occupation position. And how does one get a H1B visa? So to get a H1B visa, one should have at least a 4-year bachelor's degree or an equivalent degree. So that is a requirement, a minimum requirement. One has to have a 4-year bachelor's degree or an equivalent degree to even qualify for the H1B visa. And the H1B visa, it is typically approved for a maximum of 3 years. So anytime one gets an H1B petition filed, the maximum that USCIS could approve it is 3 years. And overall, so by applying multiple times, overall, typically one can work on H1 only for 6 years, not more than 6 years in general. However, if somebody wants to work for more than 6 years under a H1B program, they have to have an employer sponsor their green card. So if an employer sponsors their green card and goes through the perm processing and the I-140 process, then people can work for more than 6 years under H1B program. So typically for Indian nationals, it takes a long time to get a green card. So people are able to work for more than 6 years because some employer has filed a green card petition for them. And because an I-140 is approved, that is how people are able to overcome the 6-year requirement and keep working continuously until they get their green card.
Yes.
So overall, that is a summary of the H1B program.
Yes, Mr. Chand. Now, Mr. Chand, do you think that the US government will issue more H1Bs as there is a lot of demand for the tech talent out there?
Definitely, and we have to look at the historical precedents in the past. Currently, this year, we have 85,000 H1B visas that are allocated based on the laws. In the past, we have seen this number increased. So, for example, in 1998, based on the ICWIA Act in 1998, this number, the 85,000 number, was increased to 115,000. And for 1999 and 2000, the quota was set at 115,000. Again in year 2000, so this was during President Clinton's time. So he signed another act in 2000, ACWIA Act of 2000. This number was increased to 195,000. So in 2001, 2002, and 2003, we had 195,000 H1B visas allocated for those years. So technically, right now, we only have 85,000. And based on the historical precedents, this number could be increased. But for this number to be increased, it has to go through the Congress. It has to be passed. It has to be passed after the House of Representatives, the Senate agree to it, and the President signs off on it. So theoretically, yes, it is possible. And it has been done in the past. But will it be done this year? Probably not. Maybe or maybe not. However, what we know is this year there is a serious labor shortage. And the US Chamber of Commerce, it's a very powerful organization. They are actually, they have launched a campaign this year to double the number of visas. So at least we know that there is lobbying, there is pressure on the Congress to act because there is labor shortage and increasing the number will help the country. So, I mean, the labor shortage is a good reason for the government to act. But again, for the government to act, it is not a simple thing. It has to be passed by the Senate. It has to be passed by the House of Representatives. And then the president has to sign to become a law. Out of all the last couple of years, I think this year, I think the market conditions where there is a serious labor shortage, there is a lot of work needing to be done. So I think the market conditions do dictate that the 85,000 H1B visas are probably not enough. But again, for that to become a law, there are a couple of steps that need to be passed.
Yes, Mr. Chan. Can you tell us what is a specialty occupation, especially for H1B visa?
H1B visa, the requirement is that the occupation has to be a specialty occupation. So that word, this term, specialty occupation, comes a lot. So specialty occupation means an occupation that requires theoretical and practical application of a body of highly specialized knowledge. That is one part. And the second part is a bachelor's degree in a specific specialty is required for entry into the occupation. So in layman terms, what that means is the job has to be a complex job, and the job should require a bachelor's degree. So any job that requires a 4-year degree in a specific field is what qualifies as a specialty occupation. For example, a mechanical engineering job. A mechanical engineering job requires a bachelor's degree in mechanical engineering. So one needs to be having a bachelor's degree in mechanical engineering to do a job of a mechanical engineer. So it is very clear that that job is a specialty occupation job. For example, an electric technician. An electric technician does not need to have a bachelor's degree in electrical engineering. So that job is not a specialty occupation job. And for electric technician, H1B visa cannot be granted. For electrical engineer, yes, a bachelor's degree is required, so H1B visa will be granted. So summary, all that means is if a job is a complex job that requires a bachelor's degree in a specific specialty, it is a specialty occupation job.
Yes, Mr. Chan. Can you explain us what is an H1B audit and what happens during that time?
So the wage and hour division from the Department of Labor and the USCIS, which is the US Citizenship and Immigration Services. So these two bodies are tasked with making sure that any employer who's employing a H1B employee, they're in compliance with the relevant immigration and labor laws. So these typically, when we talk about an H1B audit, we either say, I mean, depending on who has raised the audit, whether it is a DOL audit or whether it's a USCIS audit, we have to kind of handle the audit and make sure the officer gets the data that they want. And typically this audit, either a DOL H1B audit or a USCIS H1B audit, it is triggered by a number of things. Sometimes it's a random audit. So just out of the blue, somebody might be audited for no reason. Or sometimes it could be a targeted audit. A targeted audit is when somebody complains against the employer, or maybe DOL has found an issue during maybe an H1B filing. Maybe USCIS saw an issue during some H1B filing, or maybe something happened at the consulate. So these kind of things trigger an audit. And depending on the kind of the issue that the government is trying to look at, typically it is either DOL, Department of Labor, coming and trying to audit the company, or USCIS trying to come in and audit the company. And what typically happens is that they either ask for public access files or the payroll records. So they typically want to make sure that the employees are being paid on time appropriately as per the H1B petition. And they also want to make sure that the public access files are maintained properly. So these are the two most common things that are asked in an audit: public access files and the payroll records. And lately what is happening is there is another thing called site visits. So USCIS started administrative site visit and verification program in 2009. And based on this program, the fraud detection officers, they typically do a site visit. So they come either to the place where the employee is working or where the employer is located, and do an in-person visit and validate things on the H1B petition. So the site visits have also become very common. And sometimes it is just a random audit. and sometimes it is targeted. But site visits are typically more random. I mean, the site visits are more common than the regular audits in general.
Yes. So, Mr. Chan, some people say that the H1B rejections are lower. Is this true?
That is definitely true. Based on the data released by USCIS, in 2021, the first 2 quarters, the denial rate was around 7% this year, for this fiscal year, 2021 fiscal year. If you look at the first 2 quarters of 2020 during the previous administration, the denial rate was around 30%. So clearly, the denial rate has come down from 30% to 7%. So it clearly looks like USCIS has been approving a lot more cases and denying very few cases. And I think the reasons are probably because USCIS last year came up with a new memo. It is also called as an IT serve memo. So in this memo, USCIS changed the definition of employer-employee relationship. So because of that, the burden of proof on the companies is a lot easier now than what it used to be in the past. And that majorly contributed to the lowering of the denial rate, in my opinion. And that coupled with the COVID pandemic, labor shortages also probably is probably causing the lessening of denials on the H1B front. And overall, what that means is if somebody is qualified, the job is a bona fide job from a company, more than likely the case will be approved in the current scenario.
Okay, Mr. Chan. So, Mr. Chan, can you tell us, is there any new requirement for the companies to pay more wages to the H1B visa holders?
So there were some proposals in the previous administration. They tried to pass it as agency actions, but none of them have been implemented. Currently, the wage rules have not changed. So we have the same wage rules we had in the past. We have to file an LCA. We have the same wage levels, and nothing really has changed on the wage level front. The way the wage levels are computed has not changed. So as of now, there is no major change. But again, these are things that are constantly evaluated on the USCIS side. So in the future, maybe they will change. But at this point of time, there are no new changes. And as long as an LCA is certified, as long as the wages are complied, the FLC data center wages are complied, typically there should not be any issue.
Mr. Chan, did the US government allow resubmission of the rejected H1B visas for the year 2021?
So in fiscal year 2021, so right now we are in the fiscal year 2022 cap petitions. So this is fiscal year 2021. So last year they rejected some petitions and there was a court case about it. And in certain circumstances, the court came back, USCIS came back and said that they will allow for resubmission of some rejected petitions for fiscal year 2021. So the reason for that is because in the past, we always had to put October 1st as the start date in the H1B petition. But what happened last year was that there was a second lottery and USCIS said that people could file until second week of November last year. And because people were filing after October 1st, they put a date, the current date, while submitting the H1B petitions. And USCIS unfortunately rejected those petitions and said that people did not put 10/1 as the start date on the H1B petition and rejected their cases. People went to the court and based on that court case, what USCIS did is they came back and said that they will allow for resubmission of some rejected petitions if the sole reason for rejection was the start date issue. So any of those petitions where the petitions got rejected because of the start date issue, USCIS did allow for resubmission of those fiscal year 2021 H1B petitions.
Mr. Chan, tell us, when do you think the US will approve the petitions for the latest petitions for the H1B visas?
So typically most of the petitions lately, they have been getting approved very quickly compared to the prior years. So prior years, the H1Bs, they used to take about 8 to 10 months to get an approval. And upgrading it to premium and paying a lot of fees just to get a quick approval was the only solution. However, lately what we're seeing is, some cases, regular cases are getting approved as quickly as 2 weeks time, 2 weeks, 3 weeks. Again, this is not for all the H1B filings, but some of the cases are starting to get approved in as short as 2 weeks time frame. And typically, majority are getting approved in less than 6 months. At least that is what we are seeing in our office. So I think the average time frames have lessened a lot compared to the previous years, and we are getting very fast approvals and not really taking a long time like what we used to see in the past.
Yes, Mr. Chand. Now, can you tell us what are the different stages of H1B visas?
Sure. So, in general, most of the petitions that get filed during the initial H1B time, uh, these are for people who are already here in the country on F1 visa. So, a lot of people who are here in US on F1 visa, they finish their master's program, and they typically, once they are done with their master's program, they typically try to convert to H1. So these are the most common kind of applicants. Then we also have applicants who are working in India, highly qualified people working in India for very good companies. They also are a good applicant pool for trying to come into US and work on H1B visa. So the life cycle for this process, it starts off with the lottery process. So the step one is getting through the lottery. So they have to find an employer, and the employer has to sponsor, has to be willing to sponsor their H1, and that employer will put them under the lottery process. This is also called as the H1B registration. So once the employee is entered into the H1B registration, this is commonly called as the H1B lottery. So the first step is get into the H1B registration, and then once the lottery happens, if they get picked up in the lottery, they go to the step two. So assuming somebody gets picked up in the lottery, now the employer is able to file their H1. So at that point of time, the employer works with either an attorney or they do the filing, and they get the H1B petition filed. So this H1B petition is a filing where they tell USCIS the salary that they will pay the employee, the kind of the job duties that the employee will perform, and also the work location that the employee will work from. So once the H1B petition is filed, USCIS will review the H1B petition, and there are two things that they will do. They will either grant an approval, or they will issue an RFE and ask for more additional documents. And if they issue an RFE and ask for more documents, the employer will have to submit additional documents. And at certain point of time, USCIS typically will be impressed and they will approve the case. And once the case is approved, if the employee is already in US, they typically start working on H1B. But if they're not in US, they're in India, they have to go through another step. And that is the final step. So they have to approach the embassy, the US embassy in India, get an approval, get a visa, and then come into the country and start working for the employer. So high level, to summarize, the H1B lottery, then the H1B filing, and then the H1B visa at an embassy in India. So these are the three steps before somebody could start working on a H1B.
Yes. Thank you, Mr. Chand. Mr. Chand, now that we've discussed about the lottery system and the lotteries, do you think there will be a third lottery this year? And if yes, when do you think it's going to happen?
So this third lottery just happened 2 weeks back. So USCIS did come out and this is the first year we had a third lottery. Last year we only had two lotteries. This year it was unexpected, but apparently a lot of people who got selected in the second lottery did not file. So USCIS did a third lottery, and now they are giving whoever got selected in the lottery, they're giving those employers time until February 22nd to file the H1s. So the third lottery just recently got announced. More registrations got selected, and so the employers would have to log into their My USCIS account to make sure if anybody got selected in the lottery. And whoever are lucky people who got selected in the lottery, they should make sure they finalize their H1B petitions as soon as possible and they get it filed with USCIS. So that way, hopefully, they'll have an approval soon. And if something were to happen, they have a backup because the new H1Bs are again about to start in March, the new H1B registrations.
Mr. Chand, like we discussed, can you tell us a little bit more about the L2 visas not having any special employment anymore?
Right. So USCIS in their policy guidance that came out last month, they agree that the work authorization for the spouses of L1 visa holders, which is typically called as the L2 visa. So these spouses of the L1 visa holders, USCIS agrees that their work authorization is incident to their status. What that means is USCIS agrees that they do not have to do any separate filing. They don't have to apply for work authorization like they're currently doing. So currently they have to apply for I-765 form. They have to pay the fees and then wait for a few months to get an approval. So all of that is now eliminated. They don't have to pay any additional fees. They don't have to file any new application. They're directly eligible to work if they are the spouses of L1 visa holders. So it is incident to their status. So this is a great thing for the L1 spouses, and it will not only save money, it will also save the headache of worrying about the EAD card approval. So they can immediately start working without any filings with USCIS.
Yes, Mr. Chand. Can you tell us what are the big no's, like what are the big no's that the H1B visa appliers or the holders should do, especially during this pandemic season?
Sure. Again, the most important thing for anybody on H1B is to comply with the law. So the H1B compliance is very, very important. And in terms of H1B compliance, what that means is they are supposed to work only for that employer. They are supposed to get paid. They're also supposed to work only from the location that that petition allows them to work from. So if somebody's H1B petition says they're supposed to work as a software developer in Dallas area, if they're working in Austin, because nowadays because of COVID, people are working from remote locations, they cannot just go to their friend's house in Austin and start working from Austin. So they have to be very careful about H1B compliance. So they have to really make sure they're working from a location that they have an approval, and they're only working in the field that they're allowed to work from. Anytime there is any material change, it is not a problem. All they have to do is notify USCIS. So there is something what is called an amendment filing. So they can always do an amendment filing if there is any material change. And by doing that, they'll be complying with the law. So the main thing to note is anybody on H1B, make sure you're complying with the law, and take H1B compliance very, very seriously, because nowadays the site visits are very common. And if there is a site visit and they find that somebody is not complying with the law, it is very common to see notice of intent to revoke requests to revoke the H1B status. So again, as long as somebody is complying with the law, following everything they're supposed to do, there is nothing to worry. And even their visa stampings down the line, when they travel to India to get their visa stamping, things will be very smooth.
Yes. Lastly, Mr. Chand, any golden information about the immigration this week that you want to give to our viewers?
Again, the main thing is compliance. Always compliance should be on everybody's minds. And what that means is following the law of the land, following immigration laws, following federal laws, following the state laws, following the local laws. So one has to be very, very cautious. I mean, sometimes for simple things such as, I would not call it a simple thing. Say somebody is driving under the influence of alcohol or something. Something like that could get somebody in serious trouble. So be very, very cautious. Do not, even if something is very minor, do not break the law. Things like speeding, things like, driving under the influence. So any of these things, be extra cautious. Do not take a chance. It is not worth taking a chance, because even a small mark on your record could impact your visa stampings when you go back for the visa stamping. And again, the reality is that majority of the Indians always follow the law. They very rarely get into trouble with the law, which is why as a community, if you see the contributions of the Indian community, you can see the success. And again, as long as somebody is complying with the law, hopefully they don't have any surprises when they go for their visa stampings. And by doing so, it will also help the system run very smoothly.
Yes, that was great information, Mr. Chand Garu. And thank you so much for joining us today. We had a great show, and thank you to the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.